As a general rule, defendants who are jointly charged with a crime are supposed to be tried together. However, as a practical matter, joint trials are rare, as the legal jiu-jitsu necessary to navigate a joint trial while still protecting the constitutional rights of all defendants is nearly impossible to achieve. Here are the three most common issues with joint trials that will cause a judge to require that the defendants be tried separately. Number one, when the prosecution intends to present evidence that's admissible against one defendant but not the other. This is most common in situations where the prosecution wants to use the defendant's statements at trial. These statements are always admissible as the defendant's admission, but in a trial involving co-defendants, the statements of a co-defendant would typically be excluded by the rule against hearsay evidence. Number two, when defenses are antagonistic to each other. An example of this would be a case where both defendants are charged with robbery and each wants to say that the other one committed the crime. Number three, when a co-defendant will testify on behalf of the other defendant. This would be a situation where one defendant would seek to testify in favor of the other defendant, but would likely be unable to do so in his or her own trial. So think of our robbery case, but imagine that one co-defendant will testify that the other did not participate in the robbery, but if they were tried together, he would invoke his right to remain silent and thereby deprive his co-defendant of that crucial testimony.